Pam Bondi once said that hearings can expose the deepest cracks in how power is wielded. But what unfolded in this exchange between Congressman Dan Goldman and Secretary Kristi Noem wasn't just a routine back and forth. It was an explosive clash over the very foundation of American government, whether we still live under a system of laws or whether accusations and labels alone can strip away rights. What started as a question about one immigrant's case quickly unraveled into a showdown about the rule of law itself, and the stakes could not have been higher. Goldman began by anchoring the conversation in something every schoolchild learns, but most politicians try to sidestep.
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today, that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence...
So
you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
so
sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that.
No.
Investigators and law
that is
enforcement
you
officers
making that
in the case
determination.
they built against him. If you don't
the
trust our law
court
enforcement
has considered all that. The judge has considered all that, Madam Secretary.
And
if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic
must take
and human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution,
Gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now recognize.
He asked Noem which branch of government has the authority to interpret the law, the judiciary or the executive. It wasn't a trick question, it was a reminder. Congress writes the laws, the executive enforces them, and the judiciary through courts interprets and applies them. Goldman's question wasn't meant to test her memory, it was meant to box her in, because once you acknowledge that courts have the final say, ignoring their orders becomes indefensible. At the heart of the exchange was a man named Kilmar Abrego Garcia. According to the government, he was an MS-13 member, a dangerous figure. According to the judiciary, however, that accusation did not override his legal protections. The Supreme Court ruled unanimously 9-0 that Garcia had been denied due process. The court's decision made clear that an existing withholding order barred his deportation until proper proceedings took place. That distinction matters because withholding of removal is not a favor handed out by officials, it is a legal protection written into statute. Once granted by an immigration judge, it can't just be brushed aside with an accusation. The government has to go back to court, present evidence, and get the order terminated lawfully. Goldman pressed on that point with precision. He cited the Fourth Circuit, where Judge Wilkinson reminded the government that saying someone is MS-13 is not enough. The government must prove it through process. Yet Noem under oath kept returning to the same refrain. Law enforcement said he was dangerous. The department said he was MS-13. End of story. But that wasn't the story. The story was about who gets to decide. In America, it's not the executive who declares someone guilty by decree, it's the courts that weigh evidence and issue binding rulings. That's why this exchange cut so deep. Goldman wasn't defending Garcia's character, he was defending the architecture of the Constitution itself. He hammered home that due process is not a courtesy offered to the likable. It is the operating system of democracy. You don't cure a violation by insisting you already knew the answer. You cure it by following the rules and proving your case in court. And if the evidence is as overwhelming as officials claim, they should have no fear of presenting it before a judge. Yet the refusal to follow that path told a different story, a story of power unwilling to be checked. Noem tried to flip the narrative. She accused Goldman of fighting for a terrorist instead of his constituents. It was a rhetorical move designed to turn a constitutional argument into a character argument. If you insist on process, she suggested, you're siding with the dangerous. But Goldman refused to let that framing stand. He wasn't advocating for Garcia. He was advocating for the supremacy of a court order, one backed by the highest court in the land. That distinction is everything. Because once you start deciding that some people don't deserve rights, you've abandoned the principle that rights apply to all. The deeper danger Goldman exposed was that compliance isn't passive. When the Supreme Court says someone was unlawfully deported and is entitled to process, the government doesn't get to shrug and say, well, he's already gone. Courts expect agencies to act. That means coordinating travel, issuing parole authority for re-entry, liaising with foreign counterparts, joining or not opposing motions to reopen cases. These aren't favors to the individual. They're obligations to the system of justice. When Noem waved away the court's ruling by saying Garcia was back in El Salvador and that was the end of it, Goldman cut back sharply. That isn't compliance, that's defiance. And here's the risk most viewers miss. When executive officials treat court orders as optional, they don't just weaken one case, they weaken the entire separation of powers. Agencies rely on courts to defend their actions tomorrow. But if they corrode that legitimacy today by ignoring rulings, they are sawing off the branch they're sitting on. Goldman saw that risk clearly. His repeated demand, "What steps have you taken?" wasn't political theater. It was oversight at its most urgent. He was asking whether the government itself would honor the binding rules of the Constitution. This is why the moment mattered beyond the shouting. Because even if Garcia were every bit as dangerous as claimed, the law requires evidence and process, not labels. Immigration statutes are precise. Grounds of removability, evidentiary standards, burdens of proof, they all exist for a reason. To collapse those distinctions by decree is to erode the law itself. If the government can sidestep rules with a simple accusation, then the protections meant for everyone lose their force. Today it's an alleged gang member. Tomorrow it could be a journalist, a dissident, or simply someone caught in a clerical error. That's the uncomfortable truth Goldman forced into the spotlight. Courts don't give suggestions, they give orders. And when officials ignore those orders, it's not just a violation of process, it's a threat to constitutional government itself. Rights are tested not in how they protect the beloved, but in how they shield the despised. If we only follow court orders when they're convenient, then the rights we claim to cherish are nothing more than paper promises. So what should viewers take away from this fiery exchange? First, due process is not optional, it is the foundation of every freedom we have. Second, accusations, no matter how grave, are not a substitute for adjudication. And third, the health of democracy isn't measured by the volume of the shouting in hearings, but by whether officials obey the courts when the cameras are off. Goldman's clash with Noem wasn't just about one man's fate, it was about the future of separation of powers in America. Do we live under laws, or under labels? That's the question that lingers long after the microphones cool down. And if you care about the rule of law, about a system where rights apply even to the accused, then this isn't just a headline, it's a warning. Because if leaders can erase rights with a word, then those rights were never real. Stay alert, keep asking questions, and never forget democracy only works if enough of us insist that it does.